Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right. We're back. We're back with the Truth Attack. So, we are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating and the shows coming. So, if you enjoy the information, the lectures, the shows, the discussions, the topics, the hosts and the guests on the other shows as well on the network, we sure would appreciate it if you could find your way over to the libertyworksradionetwork.com website. That's all one long string, Liberty Works Radio Network, because only Liberty works. Nothing else provides prosperity but liberty. Okay, so libertyworksradionetwork.com. We need your support. Find your way over to the website. Get signed up as a monthly subscribing member, even if it's as little as $10, $20 a month. Every membership counts, and we do need your support to keep operating. And of course, if you want to get fully informed on my favorite topic, which is the maladministration of the federal income tax, is an unconstitutional tax, a direct tax without limitation, a non-apportioned direct tax under the 16th Amendment, according to the IRS, the DOJ, and all 13 of the lower circuit courts of appeals for the last 50 years. It's all been exposed as a constitutional fraud, and it's all written up over at taxfreedom.com. That's www.tax-freedom.com. Got all the information about how the Supreme Court last June ruled in a manner that effectively destroys the IRS's ability to assess the tax as a direct tax on earnings, allegedly sources of gross income under Section 61, because the only way to use that as a basis for assessing the tax is if the tax is a direct tax on labor. And since the Supreme Court says it's not a direct tax under the 16th Amendment, it's not a non-apportioned direct tax because all direct taxes must still be apportioned to the states for collection. So the IRS, the DOJ, and the federal courts have unconstitutionally been enforcing a direct tax without apportionment, and they haven't been enforcing it on the states. They've been enforcing it on individuals in violation of the Constitution, just like the American people have been telling them for 45 years. Well, the courts tell them that's frivolous. Well, it turns out it's the circuit courts that are frivolous. Not only are they frivolous, but they're lying. The judges of the circuit courts and the district courts are lying to you, America. They're lying about the income tax. Non-apportioned direct tax is the equivalent to the second plank of the Communist Manifesto, which, of course, is one of the mechanisms by which the communist government seizes control of the means of production: factories, land and labor, natural resources. It's the second plank of the Communist Manifesto. That's what the courts have been enforcing: a heavy, progressive, or graduated income tax. That's the second plank. You don't find graduated taxation in the Constitution. There's no authority within the court or the Congress to discriminate against the American people on the basis of productivity or income or wealth. That's unconstitutional. There's no more basis for discriminating on the basis of income than there is for color. Discriminating on the basis of color, race, national origin, age, gender, sexual preference, national origin. Congress has no authority to discriminate on any basis, and not on wealth or income or earnings. And there can be no direct taxation of the labor of the American people. And the whole thing is a constitutional fraud that came out of their successful implementation of another fraudulent version of the tax, the victory tax in World War II, when they took advantage of the American people's willingness to sacrifice to save the world from the Nazi threat in the European theater and the Imperial Japanese in the Pacific. Literally, what, not quite by ourselves, but hey, how much help was Montgomery in Europe? And tell me, who showed up in the Pacific? Who was there at EO, Guadalcanal, and the others? Just the Marines, I think. I could be wrong, but I don't think so. Okay, so they took advantage of the American people during World War II to convince everyone it was your duty, patriotic duty, to sacrifice and contribute a portion of your labor. Everybody's got to pay their fair share. Show me fair share in the Constitution. It isn't there. What's there is impost, duty, and excise. Impost tax is foreign activity, and the original income tax was a tariff act, which is an impost that taxed foreign activity, foreign imports, and the labor of foreign persons in America and all payments made to them. Persons being both individuals and corporations. That was the extent of the original income tax in 1913. It taxed foreign persons and in foreign places like the territories of the possessions. We can see that faithfully implemented in the original legislation of the treaty, the original act of the treaty, where the United States is redefined as the territories and possessions in D.C. And we see that faithfully implemented in law 26 years later in the statutes at large in 1939 in Section 4, where all of the classes of persons subject to the Special Income Tax Act of the Tariff Act of 1913 are listed and identified. And what's there are the non-resident aliens, the foreign corporations, and the mutual trade companies and other foreign companies, China trade companies, foreign persons, and persons in the territories and possessions, or who derive a large portion of their income from the possessions. But nowhere in any of the classes do we see 50 citizens of the 50 states subject to the income tax, because the federal government has no constitutional authority to tax the labor and the earnings of the American people in the 50 states. Only in the possessions where they're the territorial authority. But they can't invade the states to exercise that sort of authority. There's no privilege enjoyed of protection of the federal government as there is in the possessions. In the states, you're protected by the state government, not the federal government. There's no taxable privilege. There's no basis for federal tax of labor in the 50 states. That's all been done by judicial legislation. Judges who rewrote the law with their own opinions according to communist second plank of the manifesto. And this is what was done in 1955 in the case of Glenshaw Glass v. Commissioner. The Supreme Court ruled that Section 61, coming out of Section 22A, was laid by Congress to tax all accessions to wealth. And of course, that's completely fraudulent. When you examine how a code section is applied after recodification from one code section to another, as what occurred with Section 61, which came from Section 22A in the 1939 statutes at large, when you're examining how the law is applied after that sort of recodification, it's essential to trace the previous code section back to its original legislation, the original act that created the legislation, that created the statute. Because the original legislation can oftentimes be very revealing about the true nature or the true scope or the limited scope and range of the statute's applicability. And as we saw with the original income tax legislation of 1913, which was the Underwood-Simmons Tariff Act of October 3rd, 1913, when we trace the Section 1 tax imposed back to that original legislation, we find that it is a tariff act where the tax is collected from foreign persons when payments are made to them. The act provides for collecting the tax at the source. That is, makes it the duty of the corporations, etc., to retain and pay the sum of the tax. I'm quoting the Supreme Court in Bruchaber versus Union Pacific, where they're laying out the nature of the scheme of taxation and the provisions of the tax law that they're testing. They say it's the duty of the corporations, etc., to retain and pay the sum of the tax. What they're talking about is a tax that is collected by tax collectors who withhold money as tax from payments made to taxable persons. And when we research this collection of the tax by tax collectors, as implemented in the original laws of 1913, what we find is that the original legislation created a class of tax collectors called withholding agents. Withholding agents are defined in law at 7701A16. A1 is where the term person is defined for use throughout the title. So we know that 7701A provides definitions that can be used throughout the title, and such is the case with 7701A16, the withholding agent. And that definition says the withholding agent is any person required to deduct and withhold any tax under the provisions of 1441, 1442, 1443, and 1461. And when we research those sections, we find that 1441 requires the tax collector, the withholding agent, to collect tax from non-resident aliens. 1442 requires him to collect tax by withholding money as tax from payments made to foreign corporations. 1443 requires the same withholding from foreign tax-exempt organizations at a slightly lower rate of withholding. And 1461 says that tax collector, the withholding agent, is the person liable for the payment of the tax to the Treasury, because he's the person with the duty to retain and pay the sum of the tax, according to the Supreme Court. Here it is. Here's the indirect taxation of foreigners by tax collectors who don't pay tax out of their own pocket. They shift the burden of the indirect tax by taking the tax from the pocket of other persons with whom they're doing business, and they're only liable for sending in what they have collected from others, never paying tax out of their own pocket or on their own earnings. That's all that was in the original law. That's what got tested in Brushaber. The act provides for collecting the tax at the source. This was always about collection of the tax at the source. And they created a new class of tax collectors, withholding agents, who collected it from foreigners under the provisions of the Tariff Act, which is an impost, which is one of the three forms of indirect taxation allowed by Article 1, Section 8, Clause 1, that provide for the taxation of foreign activity, foreign persons, foreign imports, and in foreign places. Imposts don't tax domestic activity in the 50 states. Duties are taxes on exported goods. That's why we have duty-free shops at the airports. If you're leaving the country, you can buy American goods completely tax-free and take them overseas to either consume or resell in foreign markets, free of American taxes. We have foregone duties in this country because we don't have any natural resource shortages or goods that we need to keep in this country. And we don't punish our producers, our companies, for successfully selling into overseas markets. We encourage it. So we don't have duties that would ever reach labor of the American people in the 50 state. And excises tax the manufacture, consumption, and sale of commodities within the country, things like ATF, alcohol, tobacco, and firearms. They tax licenses to pursue certain occupations like selling alcohol, tobacco, and firearms, or transporting petroleum fuels across state lines. And excise tax the corporate privilege, where it is the privilege of incorporation or the license holder. It is the privilege that is the subject of the tax. And income is the yardstick that measures the amount of tax owed on the earnings derived from the federally taxable activity subject to some impost, duty, or excise. But Title 15, Section 17 says the labor of a human being is not a commodity or article of commerce. And that statute precludes any argument that the labor of the American people are subject to federal tax because labor is a commodity. The labor unions wrote that out in the late 30s when they saw this coming, and nobody's paid any attention to it. There is no basis to tax the labor of the American people indirectly by impost, duty, or excise. The 16th Amendment created no new powers to tax, neither direct nor indirect. So, what is the income tax if it's not part of impost, duty, and excise? I think I hear the first commercial break, so this is Thomas Freed on the Liberty Works Radio Network. We'll be back in 5 with more. Please find your way over to the LibertyWorksRadioNetwork.com website and get signed up as a monthly subscribing member. Oh, that's right. We have to Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and we're going to get right back into it. As I was saying when we left, you had the 16th Amendment passed in 1916, which essentially didn't do anything. The Supreme Court said no new powers are created. That means it can't be the direct tax that the circuit courts have claimed it authorized since 1980 and before, so basically 50 years of constitutional fraud. And it can't be a new power to tax indirectly, with income being a fourth new power beyond impost, duty, and excise. That was never the situation beforehand. As I said, income was the yardstick. It wasn't the subject of taxation nor the object of the tax. It was the yardstick that measured the amount of tax owed on the earnings derived from the activity subject to some federal tax by impost, duty, or excise. Foreign persons, import, export in foreign places, commodities, licenses, corporations. Those are the only things, those are the only activities and transactions subject to indirect federal taxation, both before the 16th Amendment and afterwards. And you'll say, well, then what did the 16th Amendment do? And this actually is one of the government's arguments in the court. Well, that's absurd. That means the 16th Amendment didn't do anything at all. Well, there's a whole bunch of problems with claiming the 16th Amendment authorized a direct tax without apportionment or limitation. First of all, the word direct isn't in the amendment. So if you engineer that interpretation by adding words that aren't there, you also engineer an inherent irreconcilable conflict with two pre-existing clauses of the Constitution in Article 1, Section 2, Clause 3, which says representatives and direct taxes shall be apportioned amongst the several states, and with Article 1, Section 9, Clause 4, which says no capitation or other direct tax shall be laid unless in proportion to the census hereinbefore required to be taken. And the Supreme Court tells us in more, back in June, just 8 months ago, 9 months ago, 6, 7, whatever, 7 months ago, June of 2024, last year, they tell us direct taxes still must be apportioned and laid in proportion to the census. There has never been a non-apportioned direct tax that the circuit courts made up with judicial legislation at the constitutional level. So the word direct isn't there. If you add it, you engineer an irreconcilable conflict that's inherent. That's with two pre-existing clauses that were not repealed or amended in conjunction with the adoption of the 16th Amendment, which additionally, even if you do accept the argument that it creates a new power to tax, where's the enabling enforcement clause to authorize Congress to write law to enforce that new power? That's part of the reason why the Supreme Court said no new powers are created. How could a new power be created when there's no authority to write law to enforce any alleged such new power? It doesn't exist. Oh, well, then the 16th Amendment doesn't do anything. Yes, it does. It does exactly what it was supposed to do. It was never supposed to be applied as a new power to tax to the American people. What it does is it stops the Supreme Court from doing what they did in 1896. In 1896, in Pollock Farmers Loan and Trust, the Supreme Court ruled that the legislation being tested in that case was unconstitutionally direct because of the source taxed. Because the source that was taxed was property, and taxes on property and persons are direct. So this was a tax that was, because of the source, a direct tax. And as a direct tax, it couldn't be sustained because it wasn't apportioned to the states. So the court ruled that because of the source of the revenue being property, that was a direct tax that couldn't be sustained because it wasn't apportioned to the states for payment. And of course, my opinion is that Pollock was a nonsensical decision. The tax was indirect because it was either money being earned by a corporation or it was rent being paid to that corporate person by not the property. Property doesn't write a check to be the source of rent. Rent streams from a third-party tenant's use of the property. And when you use the property to grow crops, you deplete the property, which is consumption of the commodity of land, and that's excise taxation straight up the line. So it could have been justified as an indirect excise tax, either on the corporate privilege of earning money as a corporation, or on the basis of the rent was being paid by a tenant to consume or use the commodity. Either way, it's a legitimate indirect tax. It was never a direct tax because of the source. So Pollock is nonsense, but because they ruled it was direct because of the source, that meant the Fabian liberal progressive of that era, 1900, couldn't have a tax on sources. And that meant they'd never get around to taxing the American people. So they spent 20 years, from 1896 forward to 1913, well, 17 years, working to get the 16th Amendment passed. And what the 16th Amendment says is Congress shall have power to lay and collect taxes from whatever source derived, without apportionment and without regard to any census or enumeration. And again, if you interpret that as a direct tax, you've engineered an irreconcilable conflict with the pre-existing clauses of the amendment, which are not repealed or amendment. And you tried to create a power for which there is no authority for Congress to write law to enforce. So you can't do that. So without authority to write law, what does the 16th Amendment do? I'll tell you what it does. It controls the judges of the Supreme Court. They can never again rule that a tax is unconstitutionally direct because of the source taxed. So they can never do again what they did in Pollock. It gets rid of the source prohibition as a basis for direct taxation or indirect taxation. It stops them from using sources as a basis because, of course, the basis for indirect taxation is impost, foreign activity, duty, exports, or excise, commodities, licenses, and corporations. There is no indirect basis for the taxation of the labor of the American people under the Constitution when the people are in the 50 states. The government can only tax wages and salaries in the territories and possessions. And again, we see that laid out clearly in the 1939 statutes at large. Section 4, I have it on the website, taxfreedom.com. All of this information is there, laying all of this out. So they spent 20 years, the Fabian progressives of the 1900s spent 17 years trying to get rid of the source prohibition under Pollock. And they got the 16th Amendment in place, but they didn't tax the citizens of America, and that would be unheard of previous to World War II. You can't tax labor. That's a direct tax if the person who earns the money has to pay the tax, because it can't be avoided, and every time you work to earn $1, you owe tax to the federal government. That's not only direct taxation, it's a form of enslavement. It's just not using whips and chains. It's using economic extortion and threats of financial harm, if not violence. So there was never any intent to tax the labor of the American people under the 16th Amendment. It was passed to control the federal judges, and there was no taxation of the American people's earnings, of their rent, their interest, their dividends, their deposits, their alimony, their commissions, their annuities. None of it was taxed from 1913 to 1942. None of it was taxed. So, and it wasn't until 1942 and the victory tax that began to happen. And in 1942, they passed the victory tax, which lasted for 2 years and expired in 1944. And when the victory tax expired, Congress looked around and said, oh my God, no one objected, no one complained. We nearly paid off the war debt in 2 years. We can't let this power die. So they passed a new legislation in 1945, the current Subtitle C employment tax laws that we're under today, and they did exactly the same thing in 1945 that they did in 1913. They created a new class of tax collectors. This time they're called employers. And the employers have authority to collect tax, not just from foreigners, as did the withholding agents, but the employer can collect tax from anybody who asks the employer to collect tax from them. And that's what the W-4 does. It persuades by deception the American people to subject themselves to the payment of a tax that is not imposed on their wages and cannot be imposed on their wages under the Constitution. It simply can't be done. The labor isn't subject to taxation, neither indirectly nor directly. It has to be an impost duty or an excise, or else it's not a constitutional tax. And of course, as I said, the DOJ and the federal courts have been enforcing it unconstitutionally for 50 years as a direct tax on all sources of earnings. But sources of earnings of gross income under Section 61 can't be the basis of an indirect tax. That has to be foreign, import, export, corporate, commodity, or license. And since the Supreme Court tells us and more that the federal income tax is an indirect tax under authority of Article 1, Section 8, Clause 1, that it is not a non-apportioned direct tax, because all direct taxes still have to be apportioned, and that there are no new powers to tax and no new subjects made subject to any federal taxation, newly created or authorized or enforceable under the 16th Amendment. It did not create new power. The American people have been lied to since World War II. That's been the basis for an unconstitutional application of the federal income tax as though it were the second plank of the Communist Manifesto. The courts have been enforcing the practice of communism on the American people, not constitutional taxation. How can people not be interested in this discussion, this knowledge, this awareness that your government, the judiciary, the pillars of honesty and integrity have defrauded the American people for 50 years and actively imposed fines and penalties on the American people for trying to correct the error and pointing out the proper argument under the Constitution, which the courts have absolutely refused to review or respect. There is a judicial rebellion of sedition of judicial legislation that has been ongoing in the federal circuit courts and then the district courts, which adopted the circuit court positions, for over 50 years. And this is undeniable. It's published in every single one of the IRS's frivolous position documents, which is available again through the taxfreedom.com website. Over and over and over again, every single circuit cites case after case after case. It's a non-apportioned direct tax. It's frivolous to claim it's anything else. It's a non-apportioned direct tax. Every single circuit has engaged in this judicial legislation of sedition of the Constitution, the perversion of the the subversion of our government, which as a result of having access to unlimited amounts of funds has grown an ever-expanding unlimited bureaucracy that invades and rules every aspect of our life without respect for the limitations imposed by the Constitution and the lack of authority granted by it for the government to be involved in things like energy, agriculture, labor, health and human services, housing, transportation, environmental protection, occupational safety. Where's the constitutional authority for any of these things? These are all state activities that the states clearly don't have the money to fund. So the federal government has stepped in with the unlimited funding they have and access to the federal income tax. And the result is an omnipotent bureaucratic state that has grown out of regulatory deference and unlimited funding that the American people collateralize with their employment taxes, which don't go to the Treasury, they go to the private corporation, the Federal Reserve Bank. It's a system of peonage enslavement, not constitutional taxation. I think I hear the second commercial break coming up. This is Thomas Freed. We'll be back in 5. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and let's just roll back into it. As that commercial break came up, I was saying that America has been suffering under an era of judicial insurrection. Judicial insurrection. That's where the insurrection has been occurring for the last 50 years. Not 4 years ago on January 6th at the Capitol. That was a mostly peaceful protest, as I've said repeatedly. And it appears to have been a Nancy Pelosi setup, which I said when it occurred. So the judicial insurrection is what's been destroying America. Since World War II, the judges have been allowing the enforcement of the federal tax, actually writing it into precedent. It gets invoked and upheld by every court in the country. Enforcing the income tax is a second plank of the Communist Manifesto, an unconstitutional graduated tax that discriminates the American people, divides them into classes, and is responsible for the class warfare we see playing out in our streets today, in the war between the poor and the rich, the left and the right. This is a result of the different laws allowed by the income tax, which have the people in Congress believing they can write different laws for different groups of people. It doesn't have to be one law for everybody. The law doesn't have to be uniform. We can treat the blacks one way and the whites another, the Jews one way and the Christians another, and the Islams a third. And what about the Amish? And how about the Irish and the Italians? We can treat them differently, right? And the gay and the straight and the man and the woman and the young and the old and the Italian and the Irish? Well, according to this theory of geographical uniformity, that would all be just fine, provided every group in New York was treated the same as every group in California and Texas. But it's perfectly okay to break America into groups and treat them differently as long as it's geographically uniform. Yeah, baloney, liar, seditionist, insurrectionist. You fraud, you communist. That's where you find graduated taxation. Communism. Divide the people and set them at war with one another. Print unlimited sums of money so that whenever either side calls for more government interference to end the class warfare they engineered, the government will have the money to step in. Oh, and surprise, a whole new agency too. Energy, education, agriculture, housing, environment, occupational safety, health and human services, labor. They'll control it all because they can print all the money they want and borrow it to fund the expansion of the bureaucratic state, which gets the freedom to rewrite law under the regulatory deference that once was Chevron. So you've been ruled by bad socialist decisions from a communist seditious court in the 50s and the 60s, and this court is correcting the liberal error. They threw out Roe v. Wade. It's a state issue. Fed's out of it. They threw out regulatory deference under Chevron. Loper Bright terminates it. They threw out affirmative action because the solution to past discrimination is not more discrimination in the future, just of a reverse nature this time. No. And this is the last piece of the communist socialist treason that has been inflicted on the American people by a seditious and insurrectionist judiciary. And the Supreme Court's been part of it previous to this court because they stood by and let it happen and watched it happen as the government expanded and expanded and created each and every agency which is funded by the ever-growing debt, which is only loaned to the Congress because the American people's labor has been enslaved in this peonage system that lies to you, tells you they got to collect tax from your salaries and wages by your employer. It's tax. Well, if it's tax, how come it's not being deposited in the Treasury as required by law of all collected taxes under Section 7809? Where's the certification showing your name, social security number, and amount of tax paid by you as a result of the collected tax, which is required to be deposited in the Treasury? Where is that? It doesn't exist. You know how you know? Otherwise, you wouldn't have to file the return. The tax was already paid. It was collected and turned into the treasury and receipted as being paid by you in the amount owed. You don't have to file to pay tax. It's already been collected, and if the law was followed, it's been deposited in the treasury. But guess what? It hasn't been deposited in the treasury because they're not following the law. It's not law. It's communism. It's the end of freedom, liberty, end of the republic. And as long as the American people collectively allow their labor to be collateral and serve as the collateral for the $36 trillion owed to the Federal Reserve Bank, the Federal Reserve Bank will continue to lend you into oblivion. Because as goes the currency, so goes the fate of the nation and the quality of life of its population. It's a peonage system. You're being robbed of a percentage of the fruits of your labor resultant from your right to work, and rights are not taxable, neither the possession nor the exercise after the fact, nor the resulting consequences, i.e. fruits of labor. None of it is taxable. Rent, interest, dividend, alimony, none of it is taxable indirectly unless it's derived from a territory or possession or foreign country under tax treaty, which, as I was saying earlier, turns out to be pretty important, researching the original source of legislation, because when you research Section 61, it goes back to 22A, which it turns out was not enacted in 1913 as part of the original Tariff Act. Section 22A traces its origins to 1918 and a completely different piece of legislation than the Underwood-Simmons Tariff Act of October 3rd, 1913, which is the original income tax legislation. So what piece of legislation in 1918 does Section 22A trace to? It's a Canadian tax treaty. A 75-year-long Canadian tax treaty. That's where 22A applies. Rent, interest, dividend, everything earned by a citizen from sources in Canada under the treaty, whether you're living there or just working there. That's what's subject to gross income. That's what is gross income. Only money earned in Canada under a tax treaty. And the treaty lasted for 75 years, from 1918 to 1993. But when the treaty expired, so too did Section 61, which was 22A, which was enacted under this treaty and only applied in Canada. This was never domestic legislation. So when the Supreme Court takes Section 61 in 1955 in Glenshaw Glass versus Commissioner and says that Section 61 is where Congress decided to tax all accessions to wealth, including all these sources, rent, interest, dividends, compensation, annuities, alimony, da-da-da-da-da-da-da-da-da. They perverted the constitutional application of the tax and turned it into the second plank of the Communist Manifesto by making all sources in America allegedly taxable under a code section that only made sources in Canada taxable. The Supreme Court either intentionally didn't review the original legislation, or they're so stupid they missed it. You guess which one. Because I don't know if they were stupid or communist. Probably a lot of both, huh? Don't you think? Because there's no basis for the taxation of any sources of gross income in the 50 states. They're not subject to tax by impost, duty, or excise. It's not a direct tax without limitation. No, it's a tax without apportionment, and that means it's indirect, because if it were direct, it would have to be apportioned. And the court said this in 1913. As a tax without apportionment, it can only be indirect, because indirect taxes, they don't have to be apportioned. They only have to be uniform. Well, it's not uniform either, is it? Because the rich pay one rate, the productive pay another, and the poor pay another, if any. Right? We all know the rich only pay capital gains tax. They don't make wages or salaries. They live off of their assets. 13%. The hardworking man pays between what? 15 and 40%? The corporations pay 19. It's an unconstitutional direct tax on the right to work that has subjugated the American people to the ever-growing bureaucracy and its unlimited powers created by the socialist court. In engineering this source of earnings from every person based on, I guess, the success of the victory tax during World War II, and based on the expansion of the bureaucratic state by having access to all this unlimited capital. And the way to break the system is to eliminate the government agencies, cut the budget across the board 5% of everything, and then take the budgets of the eliminated agencies, cut them another 5%, and give that money to the states to administer to energy, agriculture, housing, medicine, occupational safety, environmental safety, transportation, health and human services, commerce, labor. Let the states spend the money out of the capital so that you distribute spending to all 50 state capitals instead of it all coming out of Washington, D.C. to the lobbyists and enriching only one city's population instead of 51. Give the money to the states to administer. Close down the federal bureaucracies that aren't authorized to exist. Slash the budget, and you can balance the budget cutting those state funds every year 10%. The whole budget 5%, and these state funds 10%. And the states won't mind a bit because they never got a penny before. And they'll know that up front they're getting more than they're going to get the next year because it gets cut 10% till the budget's balanced. So they'll know to plan infrastructure in the beginning to maintain staff later on with the smaller numbers. And to focus on the real problems up front, wait for the other ones later with the smaller budgets. And this way, you break the monopoly on power, you break the monopoly on spending, you break the monopoly on federal control, you eliminate the federal bureaucracies, and you bring the debt back into a balanced budget. Just across the board, slash it 5% every year, 10% of these eliminated agencies every year until the budget's balanced. Give the money to the states, break the monopoly, stimulate economic activity in 50 states, not just one city where it's all political lobbying. 3 of the wealthiest counties in the country are around Washington, D.C. because of the excessive rates they pay their employees. 3 of the wealthiest counties in the country are around the capital. Why aren't they around the 50 different capitals around the country? Yeah, I think we know why. It's because the federal government and the judges have been imposing and enforcing communism for 60 years. And this court finally looks like it's gonna shut it down. The writing's on the wall. The Supreme Court said in Moore 6 months ago, income taxes are indirect taxes under Article 1, Section 8, Clause 1. That ends the enforcement of the tax in an honest court as a direct tax without apportionment on all sources under Section 61. Labor isn't taxed indirectly unless it's the labor of a non-resident alien. That's in Section 1441B if you want to go see it. That's where compensation, wages, and salaries are all defined as 3 separate distinct sources of income when earned by a non-resident alien. But in Section 61, salaries and wages are gone. Congress removed 2 of them. Is that because a corporation can earn compensation, but it can't earn wages and salaries, and you can't tax wages and salaries because that would be unconstitutionally direct taxation of the labor of the American people in the 50 states? So they removed the word so they wouldn't have a patently unconstitutional statute and just waited for some judicial seditionist to use judicial legislation to put them back in. And ever since, America's been a slave to the system, not because of the law, not because of Congress, but because of the judges who have betrayed you and thrown you to the wolves to die in the wilderness with the thieves. This is Thomas Freed on the Liberty Works Radio Network. Get over to tax-freedom.com. Get educated, get free. We'll be back next week with more.